Karen Whitmore thought she had finally found a way to force Ethan Cole out of his own property. She was the president of the Homeowners Association, and for months she had complained about his fence, his driveway, and even the trees growing along the edge of his land. But this time she went further. She filed a lawsuit against him, claiming he had illegally moved his property line onto land that belonged to the association. Ethan did not argue with her. He did not raise his voice or threaten her. He simply called his lawyer. When Daniel Hayes opened the original property records in the courtroom, Karen's confident smile disappeared. He looked at the judge and said the defendant had never crossed the property line. The association had. Karen stood at the edge of Ethan's front yard on a gray afternoon, holding a clipboard in one hand and a folder of association papers in the other. Her phone was tucked against her shoulder, though no one seemed to be on the other end of the call. She wore the same expression she always wore when she came onto someone's property uninvited, a look that suggested she was doing them a favor simply by being there. She told Ethan that his fence had crossed onto association land, that the Homeowners Association could not allow this kind of violation to continue, and that she had already documented the intrusion with photographs. Ethan walked the length of the fence with her, pointing out the survey stakes that had been placed there years earlier by the previous owner, stakes that matched the property line exactly. Karen barely looked at them. She said she did not need him to agree with her, because the association had already made its decision. Ethan had lived next to Karen long enough to understand the pattern. She had complained about the color of his front door, insisting it violated some unwritten standard of the neighborhood, even though the same shade appeared on at least 2 other houses on the block. She had complained about a maple tree in his backyard, claiming its roots threatened a shared drainage easement, though the tree stood nearly 40 feet from any pipe. She had sent him 3 separate notices about his driveway, each one contradicting the last, one demanding he repave it, another insisting he leave it exactly as it was. She had even suggested, in a community newsletter she edited herself, that his security camera was pointed toward her house, though it had never once captured any part of her property. He had learned to treat these complaints the way one treats weather, something to be endured rather than fought, something that passed if he simply waited long enough. But standing there that afternoon, watching Karen tap her pen against the clipboard, he sensed this complaint was different. Her posture was too rigid. Her voice was too rehearsed, as though she had practiced the words before crossing the street. He had bought the house 6 years earlier, drawn to the quiet street and the mature trees lining the yard, never imagining that the greatest source of stress in his life would come not from his job or his finances, but from a woman 2 doors down who treated the Homeowners Association like a small kingdom. Karen had not always been president. She had spent years on the board in smaller roles, attending every meeting, memorizing every rule in the association's declaration, waiting for her chance to hold real authority. When she finally won the presidency, something in her seemed to change. Neighbors who once found her merely irritating began describing her as something closer to relentless. She issued citations for minor infractions that previous boards had never bothered to enforce. She organized inspections of yards and driveways with the thoroughness of an auditor. And increasingly, her attention had settled on Ethan, though he could never quite determine why. She reached into her folder and pulled out a thick envelope, pressing it into his hand before he could refuse it. She told him he had 30 days to respond. Then she turned and walked back across the street without waiting for a reply, her heels striking the pavement in short, deliberate steps. Ethan stood alone in his yard for a long moment before he opened the envelope. Inside was a formal complaint, printed on letterhead from the Homeowners Association, listing his name as the defendant and the association as the plaintiff. He read the first line twice before the weight of it settled in his chest. He was being sued by the very organization he paid dues to every year over a fence that had not moved an inch since the day he bought the house. The following week, Ethan sat at his kitchen table and read through the entire complaint again, this time slower, taking notes on a legal pad. The association accused him of encroaching on common land, of altering an established boundary without authorization, of damaging shared property values through what the document called unauthorized structural placement, and of failing to comply with prior notices from the board. The relief the association sought was equally aggressive. They wanted the fence removed at his expense. They wanted the boundary restored to what they described as its original position. They wanted him to cover the association's legal costs. And buried near the end, almost as an afterthought, they wanted damages. He read the complaint a 3rd time that evening, this time aloud to himself, trying to hear how the accusations would sound if spoken in front of a judge rather than seen printed on paper. Every claim rested on a single piece of evidence. The survey, Karen said, had been prepared for the association. There was no mention of who had performed the survey, no license number, no date of completion, only a reference to it as though its accuracy were beyond question. He set the pages down and reminded himself that accusations, however confidently written, were not the same thing as proof. He attended the next association meeting because he wanted to understand what was actually happening before he did anything else. The meeting room in the clubhouse was half full, folding chairs arranged in uneven rows beneath fluorescent lighting that buzzed faintly overhead, and Karen stood at the front with a projector screen behind her. She presented a map that she said had been prepared by a surveying company hired by the board, a map that showed his fence sitting nearly 3 feet onto what she called association property. Several members in the audience nodded along as she spoke, murmuring their agreement, the kind of quiet consensus that forms quickly when a room full of people wants to believe the person speaking with the most confidence. A woman 2 rows ahead of Ethan whispered to her husband that she had always thought that fence looked crooked. Karen's voice carried the particular confidence of someone who believed she had already won, each sentence delivered with the rhythm of a closing argument rather than a neighborhood update. She spoke for nearly 10 minutes without pause, describing the alleged encroachment in language that made it sound almost criminal, referencing property values, community standards, and what she called a pattern of disregard for association rules. She did not once look toward Ethan while she spoke, though everyone in the room understood exactly who she meant. Ethan waited until she finished before he raised his hand. He asked her, calmly, where the boundary line on her map had actually come from. Karen answered without hesitation that it came from the association's records. It was a simple answer, delivered with the same certainty she used for everything, but something about it did not sit right with Ethan. If the boundary had truly always been where her map showed it, there would have been no need for her to move so quickly, no need for a lawsuit filed within weeks of her first complaint about the fence. People who are certain of the truth rarely rush toward court. They usually have the patience to let the facts speak first. Karen did not have that patience, and Ethan began to wonder why. He left the meeting early and called Daniel Hayes that same night. Daniel was a real estate attorney Ethan had used years earlier when he first purchased the house, a quiet man who spoke in short, precise sentences and rarely wasted words on anything other than facts. He had handled dozens of boundary disputes over the course of his career, and colleagues who knew him well often said he approached each case less like a courtroom fight and more like a puzzle waiting to be solved, patient and methodical, never raising his voice even when the opposing side raised theirs. Ethan explained the lawsuit, the map, the 30-day deadline, and Karen's sudden aggression, laying out the timeline as clearly as he could manage despite the frustration still sitting heavy in his chest. Daniel listened without interrupting, occasionally asking a short clarifying question, and when Ethan finished, there was a long pause on the line, the kind of silence that told Ethan the attorney was already turning the situation over in his mind. Then Daniel told him not to move the fence. Ethan asked why, and Daniel said he wanted to see what Karen would do next, explaining that a person building a case on solid ground rarely needed to rush, while a person standing on shaky footing usually gave themselves away by moving too quickly. There was something in his tone that told Ethan this was no longer just a neighborhood dispute. It had become something Daniel intended to take apart piece by piece. Daniel began his own investigation the following week, starting with the documents that mattered most in any property dispute. He pulled the original deed to Ethan's house, the title insurance policy issued when Ethan bought the property, the survey conducted at the time of purchase, the county's official plat map, the recorded easements attached to the parcel, and the full history of ownership transfers going back decades. He worked through the stack methodically, the way he approached every case, refusing to let a single inconsistency slip past simply because it seemed minor. At first, everything appeared to support the association's position. The lines on Karen's map looked plausible when compared against a casual reading of the older documents, close enough that a less careful attorney might have accepted them without a second look. But Daniel did not read documents casually. He had spent nearly 2 decades untangling property disputes, and he had learned that the truth in these cases rarely announced itself. It hid in formatting inconsistencies, in fonts that did not match, in reference numbers that followed a different convention than the rest of a filing. He noticed something odd about the survey the association had submitted, something in the layout and the numbering system that did not match the style used by any licensed surveyor active in the county over the past 30 years. The measurements were expressed in a format the older county surveyors never used. It looked less like an original survey and more like a copy that had been altered somewhere along the way, redrawn to look authentic while quietly shifting a boundary line by several feet. He requested the county archive produce the original survey filed under the property's parcel number, the one submitted at the time the subdivision was first platted, decades before either Ethan or Karen had ever lived on the street. The clerk who handled the request warned him it might take a week or more, since older filings from that era had been moved to off-site storage, and needed to be retrieved by hand rather than pulled electronically. Daniel told Ethan not to worry about the delay, that documents which took effort to retrieve were often the ones nobody had bothered to alter, simply because they were harder to reach in the first place. It took several days for the request to process, but when the original document arrived, delivered as a slightly yellowed photocopy stamped with the county recorder's seal, Daniel laid it beside Karen's version on his desk and studied both under a bright lamp, moving a ruler carefully along each boundary line to measure the difference by hand rather than trusting his eyes alone. The boundary line in the county's original survey sat in a completely different position than the one on Karen's map, several feet further onto association land rather than onto Ethan's property, a difference too large to be explained by rounding or by the ordinary imprecision of older surveying instruments. Ethan leaned over the desk and studied the two lines himself, tracing the gap between them with his eyes, still struggling to understand how such a clear difference could have gone unnoticed for so long. He asked Daniel directly whether this meant Karen's map was simply wrong, perhaps the result of an honest mistake by whoever the association had hired. Daniel said it was not that simple. He placed both documents side by side under the lamp and pointed to the reference numbers printed in the corner of each page, explaining that the numbering sequence on the county's original followed an unbroken chain through every subsequent filing except one. Somewhere in that chain, a document had been inserted that did not belong, carrying a boundary line no earlier filing supported. He told Ethan that someone had changed the boundary, not through error, but through deliberate alteration, and that the only remaining question was who had done it and why they believed no one would ever compare the two documents side by side. The conversation shifted after that. What had begun as a neighborhood dispute about a fence now felt like something closer to a mystery. Ethan found himself asking questions he had never expected to ask about his own property. Who would have changed the boundary line, and when? Why would anyone go through the trouble of altering a survey rather than simply raising the issue through ordinary channels? Did Karen know the map she was using had been changed, or had someone handed it to her without explanation? Daniel did not answer any of these questions right away. Instead, he zoomed into a corner of the altered survey on his computer screen, where a small stamp sat in the margin, easy to miss unless someone was looking for it. It was the official seal of the Homeowners Association, applied to a document that should never have carried it. While Daniel continued digging through records, Karen did not slow down. She sent Ethan another notice, this one demanding he stop using a section of his own driveway that she claimed extended onto the disputed land, printed on association letterhead, and left taped to his front door rather than mailed through the usual channels. A week later came a second notice, insisting he remove a portion of the fence immediately, regardless of the ongoing lawsuit, a demand Daniel quickly reminded him he was under no obligation to follow while litigation remained active. She told several neighbors that the case against Ethan was essentially settled, that the lawsuit was little more than a formality before the board reclaimed what belonged to the community, and word of her confidence spread quickly along the quiet street. A few of Ethan's longtime neighbors began avoiding eye contact with him at the mailbox, uncertain whether being seen talking to him might draw Karen's attention their way. One neighbor, an elderly woman who had once brought him a plate of cookies when he first moved in, crossed to the opposite sidewalk when she saw him watering his lawn, offering only a brief, apologetic wave before hurrying on. Ethan understood the impulse even as it stung. He had watched Karen turn her attention on other households before, and he knew how quickly an ordinary neighbor could become her next target simply for showing the wrong person sympathy. Karen, for her part, seemed to enjoy the shift in atmosphere. She reminded anyone who would listen that she had a lawyer, a survey, official association records, and what she called overwhelming evidence, listing each item as though reciting a grocery list, rather than describing a lawsuit against a man who had done nothing more than build a fence along a line the county itself had drawn decades earlier. Ethan remained outwardly calm through all of it, though the pressure was beginning to wear on him privately. Daniel advised him strongly against responding publicly to any of Karen's claims, warning that anything he said in the neighborhood could be twisted and used against him later. Instead, Daniel asked him to gather every piece of paperwork related to the house, every notice the association had ever sent him, every meeting minute he could find, every email exchange with board members going back years. Ethan spent his evenings organizing folders on his kitchen table, sorting through boxes he had not opened since he moved in. During one of their calls, Daniel asked a question that seemed unrelated at first. He wanted to know exactly when Karen had become president of the Homeowners Association. Ethan checked his old emails and gave him the approximate date. Daniel went quiet on the other end of the line for several seconds. When he finally spoke again, his voice carried a different weight than before. He told Ethan he had cross-referenced the timestamp embedded in the altered survey file with the date Karen took office, and the two events lined up within a matter of months. It was not proof of anything on its own, but it was the kind of coincidence that made a careful attorney start asking harder questions. Daniel told Ethan he no longer believed Karen had simply misunderstood where the property line sat. He believed she had needed the line to be somewhere else entirely, and that belief changed the direction of everything he did next. He stopped focusing only on the fence and the survey, and began looking instead at what lay just beyond the disputed strip of land, at what the association might have wanted that piece of property for in the first place. Ethan asked him what he meant, and Daniel said only that he would need a few more days before he could say anything with confidence. Those few days turned into a deeper investigation than Ethan expected. Daniel discovered that the disputed section of land sat directly beside an area the association had been quietly discussing for redevelopment, a stretch that connected to a proposed new walking path, a planned landscaping upgrade, and a small parcel that carried unusually high value for future commercial use. He pulled the minutes from every board meeting held over the previous 18 months, reading through pages of routine business until he found what he was looking for buried in a section labeled long-term planning. Karen herself had presented an early version of this development plan at a board meeting nearly a year earlier, describing it to the other board members as an opportunity to raise property values across the entire neighborhood, though few residents outside the board had paid much attention to it at the time, and no formal vote had ever been taken. The plan called for a paved walking path connecting the clubhouse to the western edge of the community, a stretch of landscaping that would require reshaping several yards along the border, and eventually, according to a later set of minutes, a small commercial lot that could be leased to a developer for additional association revenue. Daniel traced the proposed path on a copy of the community plat and found that it ran directly through the strip of land Ethan's fence supposedly encroached upon. It was not a coincidence he was willing to dismiss. The problem, Daniel explained, was straightforward once it was laid out. If the true boundary from the original deed was allowed to stand, the association had no legal claim to the land needed for the project. The path could not be built where it was planned. The commercial parcel would shrink to something far less valuable, and the entire proposal Karen had championed would collapse before it ever reached a formal vote. Which meant, Daniel said, that if Karen wanted her development plan to move forward, she needed that strip of land to belong to the association rather than to Ethan. He continued digging, and found that the board had hired a new surveying firm the previous year, one that had never worked in the county before, and had no history with any of the older property records, a firm based nearly 2 hours away, that Daniel could find no record of ever appearing before the county's licensing board for a public hearing. That firm had produced its measurements using data supplied directly by the association rather than pulling from the county's original archive, relying entirely on a packet of documents Karen herself had compiled and handed over at the start of the engagement. Somewhere along the way, older documents that would have contradicted the new boundary had simply been left out of that packet, whether through carelessness or intention Daniel could not yet say with certainty. He requested the firm's engagement records through a formal subpoena, hoping to determine exactly what materials Karen had provided and what she had chosen to withhold, and while the firm's owner insisted his measurements were accurate based on what he had been given, he readily admitted under questioning that he had never been shown the county's original plat map at any point during the project. Daniel was careful not to claim that Karen had personally altered any document with her own hands. What mattered more, he said, was that she had built an entire lawsuit on top of an incomplete and misleading set of records, whether she had created that gap herself or simply chosen not to look too closely at it once she realized what a complete record would show. Then Daniel pulled a single sheet of paper from his file and set it on the table between them. He told Ethan this was the document that would decide the entire case, and that it represented the biggest mistake Karen had made in the whole affair. The document was an old association filing, years old, buried in a box of archived meeting records that Daniel had requested from the county recorder's office rather than from the association itself, since the association's own copy had somehow gone missing from its files sometime after Karen took office. It showed the board formally acknowledging the property boundary exactly where the original survey placed it, years before Karen had ever taken office, resolving a minor dispute with a different homeowner over an unrelated section of the community. At the bottom of the page, beneath a paragraph confirming the boundary in plain, unambiguous language, was a signature block listing every board member present at the meeting where the resolution passed. Daniel turned the page so Ethan could see it clearly, running his finger down the list of names until he reached the one near the bottom. It was Karen's own signature, dated long before she became president, back when she had served on the board in a lesser role handling routine administrative matters that rarely drew much attention. She had signed a document confirming the very boundary line she was now suing to overturn, in a meeting she had almost certainly forgotten by the time she filed her complaint against Ethan. Ethan sat back in his chair, staring at the ink on the page. Daniel explained what this meant in practical terms. Karen had not simply sued him over the wrong property line by accident. She had sued him using a boundary that her own earlier signature directly contradicted. If the case went to trial, this single page would be almost impossible for her attorneys to explain away. Ethan asked whether they could actually use the document in court, and Daniel allowed himself a small, rare smile. He said that finding this signature was precisely why he had wanted Karen to file the lawsuit in the first place, because a public complaint could be ignored, but a sworn court case created a paper trail that eventually led back to the truth. The trial date arrived on a cold morning, and Karen walked into the courthouse with the same rigid confidence she carried into every association meeting. She wore a tailored blazer and carried a leather folder, seating herself just behind the association's attorney, as though she intended to watch her victory unfold from the best possible seat. Ethan sat beside Daniel at the opposite table, watching Karen exchange a brief, satisfied glance with the board members who had come to support her, a small cluster of allies seated in the second row like an audience gathered for a performance whose ending they already believed they knew. The association's legal team opened with the survey Karen had presented months earlier, along with photographs of the fence, copies of the notices sent to Ethan, and testimony describing the alleged violation in detailed, technical language meant to sound unimpeachable. Their attorney spoke with practiced authority, walking the judge through each exhibit as though the outcome were merely a formality waiting to be confirmed. Karen sat with her arms folded, nodding slightly at each point her attorney made, occasionally leaning toward the woman beside her to whisper something that drew a small, satisfied smile. Ethan felt his stomach tighten as the attorney described his fence as an intrusion on shared community land, a phrase that made the modest wooden structure sound almost like a crime scene. He glanced at Daniel, who sat perfectly still, his expression unreadable, a legal pad in front of him bearing only a handful of short notes. Ethan had expected him to object more, to push back harder against each claim as it was made, but Daniel had told him beforehand that a good cross-examination does not interrupt a witness while they are digging their own hole. It waits until they have finished digging. Daniel, by contrast, said very little during the opening arguments. He let the association's attorney speak without interruption, occasionally jotting a short note on his legal pad. When the judge eventually asked where the boundary line on the association's map had originated, the attorney answered that it came from the association's own records. Daniel rose and asked which records specifically. The attorney produced a copy of the survey Karen had shown at the earlier meeting. Daniel asked for the original document rather than a copy, and after a pause, the attorney admitted the association did not have the original survey the copy had supposedly been made from. Daniel pressed further, asking exactly when this particular version of the boundary had first appeared in the association's files. The attorney could not answer with any precision, and for the first time that morning, Karen's expression shifted, the confidence in her posture beginning to crack. Daniel then produced the original plat map obtained directly from the county archive, the same document he had compared against Karen's version weeks earlier. He placed both maps side by side on the display screen for the entire courtroom to see. The two boundary lines did not match, not by a small margin, but by a distance that was impossible to explain, as a simple measurement error. The judge studied the screen for a long moment before asking why this county document had never been included in the association's evidence. No one at the plaintiff's table offered an answer. Karen looked down at her folder, her fingers tightening slightly around its edge. Daniel walked the court through every document in order, building the timeline piece by piece so there could be no confusion about what had happened and when. He began with the original property deed, followed by the county's plat map, the initial survey from decades earlier, the association's founding declaration, and a series of meeting minutes stretching back years. Then he introduced the document bearing Karen's own signature, the one confirming the original boundary long before the current dispute began. Finally, he placed the newer, altered survey beside all of it, the one the association had relied on to build its entire case against Ethan. He asked, without raising his voice, who had authorized the change to the boundary line. Silence spread across the plaintiff's table. No one answered. The association's attorney shuffled through his own papers, searching for something that might explain the discrepancy, but found nothing that addressed the question directly. Daniel turned toward Karen directly and asked whether she had signed the earlier document confirming the original boundary. She admitted that she had, her voice noticeably quieter than it had been at the start of the proceeding. He asked whether she had understood exactly where that boundary sat at the time she signed it. Karen hesitated, offering a vague answer about how records change over time and how her understanding of the property had evolved since then, but Daniel did not let the moment pass. He produced a transcript from an earlier association meeting, one held years before the lawsuit, in which Karen herself had told the board that the property line had never changed and never would. that any homeowner who suggested otherwise was simply mistaken. Her own words, spoken with the same certainty she always carried, were now being read back to her in a courtroom, transformed from a passing remark into evidence against her own case. Karen's attorney rose to object, arguing that a remark made years earlier held no bearing on the current dispute, but the judge overruled him, noting that a sworn party's prior statements about a material fact were entirely relevant to assessing her credibility now. Karen sat rigid in her chair, her earlier composure completely gone, watching as the very words she once used to reassure the board were used instead to unravel the case she had built. Daniel was not finished. He told the court that the association had not simply relied on flawed information. It had asked the court to force a homeowner to surrender land the association never legally owned in the first place, based on a boundary that contradicted the association's own historical records and Karen's own signed statement. The judge asked the association's attorney to explain how this discrepancy had occurred. The attorney glanced toward Karen, but she offered nothing, her earlier composure completely gone. She sat rigid in her chair, staring at the two maps still displayed on the screen, unable to reconcile the version of events she had built the case on with the documents now laid bare in front of everyone in the room. The judge did not take long to reach a decision. The court dismissed the association's claims in full, stating from the bench that the county's original survey, combined with the association's own historical acknowledgement of the boundary, left no credible basis for the lawsuit to proceed. Ethan's fence had never crossed onto association land. The boundary had always sat exactly where the original survey and the county's records placed it, unchanged since the day the subdivision was first platted. He was not required to remove any part of his fence, was not required to surrender any portion of his driveway, and owed nothing to the association in damages or legal costs. Ethan felt something in his chest loosen for the first time in months as the ruling was read aloud, though he kept his expression steady, mindful of Daniel's earlier advice not to show too much reaction in front of the room. Across the aisle, Karen stared at the table in front of her, her leather folder closed and untouched since the moment the county's original plat map had first appeared on the screen. But Daniel was not finished making his case. He asked the court to consider the broader conduct behind the lawsuit, the legal expenses Ethan had been forced to absorb defending himself against claims built on documents the association either knew were incomplete or had never bothered to verify, and the responsibility of the board members who had approved moving forward with litigation based on those same flawed materials. He reminded the court that a homeowners association carried a duty to its members to act on accurate information, particularly when the relief it sought would have stripped a private citizen of land he had rightfully owned for years. The judge agreed to review the matter of costs separately and indicated, in a tone that left little room for doubt, that the association's conduct in pursuing the case would weigh heavily in that decision. The fallout extended well beyond the courtroom. At the next association meeting, Karen stood at the front of the room as she always had, but the atmosphere had shifted entirely. The same folding chairs sat arranged in the same uneven rows, the same fluorescent lights buzzed overhead, but the faces watching her were no longer nodding in easy agreement. Board members who had once nodded along with her began asking pointed questions instead, their tone far less deferential than it had been only months earlier. One member asked directly why she had never shown the board the original county survey before filing the lawsuit, since it had clearly existed the entire time in the county archive. Another asked why she had told everyone the boundary had changed when a transcript from years earlier proved she once said the opposite, in her own voice, in that very room. A third member, an older man who rarely spoke at meetings, asked the question that seemed to hang over the entire room without anyone quite willing to say it aloud, wondering whether the lawsuit had ever really been about the fence at all, or whether it had always been about clearing the way for a development plan the board had never formally approved. Karen tried to answer, offering explanations that grew thinner with each question, her usual confidence replaced by long pauses and half-finished sentences. She reminded the board that she had only been trying to protect the community's interests, that any mistakes in the paperwork were the fault of the surveying firm rather than her own judgment, but the room no longer accepted her word the way it once had. For the first time since Ethan had known her, Karen was not the one controlling the conversation, and the silence that followed her explanations was louder than any objection could have been. Ethan's fence remained exactly where it had always stood. The boundary was formally reaffirmed in the county's records, closing the door on any future dispute over the same strip of land. The association was ordered to update its internal files to reflect the original survey, removing the altered version entirely from its records. Karen resigned from her position as president within weeks, stepping down before the board could formally push her out. A new election followed, and the association adopted stricter rules requiring any proposed boundary changes to be verified against original county documents before ever being presented to homeowners. Ethan felt no desire to humiliate Karen further, or to celebrate her downfall in front of the neighborhood. He had never wanted revenge. He had only wanted his property, and the truth about it, left alone. Daniel met him one final time to hand over a copy of the court's written ruling, the document that closed the case for good. Ethan asked whether that was really the end of it, and Daniel told him simply that it was. Ethan looked out toward the fence from his front window, the same weathered boards that had caused months of tension now standing as nothing more than an ordinary fence again, the kind most people walked past without a second thought. A few weeks later, Karen passed by his house on one of her usual evening walks, though she no longer carried a clipboard or a folder of complaints. She slowed as she reached the edge of his yard, glancing at the fence the way someone studies an old photograph, searching for a memory that no longer quite matches what they see in front of them. Then she looked at Ethan, standing near his porch, and for a moment neither of them spoke. She finally admitted, quietly, that she should have checked the records before doing any of it. Ethan agreed, telling her simply that she should have. She nodded once and continued down the sidewalk without another word. Ethan remained on his porch long after she had disappeared around the corner, looking at the fence line stretching across his yard exactly where it had always been. He thought about the 30 days he had once been given to respond to a complaint that should never have existed, about the months he had spent gathering documents at his kitchen table instead of enjoying his evenings, about the neighbors who had avoided his eyes at the mailbox simply because they were afraid of drawing Karen's attention. None of that had been necessary. None of it had ever needed to happen, if only someone had checked the original records before signing a single form. The dispute had taught him something he had not expected to learn from a fight over a few feet of dirt and wood. People with authority can make others feel small, can make them doubt what they know to be true, can bury facts under confidence and paperwork designed to overwhelm rather than clarify. A clipboard and a rehearsed voice can feel like proof to anyone willing to accept them without question. But authority is not the same as truth, and in a fight built on documents and dates and signatures, the person who stays calm and keeps asking quiet questions is often the one who ends up holding all the answers. Karen had power for a while. She had a title, a board behind her, and a story she told with total conviction, repeated so often that even she seemed to believe it by the time she filed the lawsuit. What she did not have was a boundary line that matched her own signature, and in the end, that single sheet of paper, pulled from a dusty box in a county archive, mattered more than every clipboard she had ever carried across a neighbor's lawn. The fence stood exactly where it always had, ordinary and unremarkable, and for the first time in a long while, Ethan found that he could look at it without feeling anything at all beyond quiet relief.